Welcome to Embargoed, intelligent talk about sanctions, export controls, and all things international trade for trade nerds and normal human beings alike. I'm your host, Tim O'Toole, and with me again for round 2 of the State Department sanctions episode, we have Erik Woodhouse and Josh Kretman. Welcome back, Erik and Josh.
Thanks so much.
Thanks so much.
Thanks for coming back after that horrible grilling we put you through last time. I'm surprised we got you back here. And we also have Melissa and Collmann back for the 517th episode of Embargoed. Welcome back, guys.
Thanks, Tim.
All right. So when we left off, Melissa had posed a question about a certain type of sanctions that we referred to as BPIs, which is when someone is not on the public sanctions list but is blocked pending investigations. And so why don't we throw that question out there kind of in the general context of what does state do in connection with BPIs, and then maybe more how do state and OFAC interact more generally on various types of decisions?
So on BPIs, that really is a function that OFAC undertakes fairly independently. I note that I think it was last year they actually put out a rulemaking that addressed BPIs along with a few other actions, which I thought was a valuable step. But it's it's helpful actually to frame out a little bit that there are areas where there is a lot of interaction between state and Treasury, and then some areas where there's less. So Treasury's enforcement authorities and function is really done as an exercise of independent regulatory authority that is not coordinated with the State Department at all. I would learn of enforcement actions when I was in this role when I saw the public announcement, essentially. It really is an independent function. But in other parts, as we've been touching on, there is a lot more interaction. So the creation of sanctions programs, when it comes to targeting, there's this formal consultation process, but that's really a hook for these broader policy discussions around the objectives and the means to achieve objectives in sanctions programs. And then licensing has another very particular mechanism. Practitioners will know that they often hear from OFAC that a specific license application is either in the agency or sometimes they'll say with the State Department. And that's because OFAC refers specific licenses, not all, but many specific licenses, applications to the State Department for what's called foreign policy guidance. And I touched a little bit in the last episode on how the State Department and how the team in the Bureau of Economic and Business Affairs that Josh and I worked with handles those, to take them in, consider who within the building needs to be aware of this application, who would have an interest in how this is considered, and the feedback we give to Treasury, runs that policy process, and then provides guidance back to the Treasury Department. There's a sort of analogous consultation that often goes on around general licenses, although it's more, I think, just a policy discussion rather than a formal kind of back and forth, the same way that you have for licenses. But around these sort of policy, licensing, targeting questions, there's a lot of interaction between state and Treasury and OFAC. But then OFAC does have a variety of regulatory authorities and enforcement tools that it really uses on its own in a way that is independent and not coordinated.
Excellent. Josh, any follow-up on that, or was your experience similar?
Yeah, very much so. I think that OFAC would, I'm trying to think about how best to put this, probably be disinclined to have state play more of an active role in determining when and how to use some of the tools that Erik was alluding to, like BPIs and other things like that. And on the enforcement side, the State Department really has no input into the enforcement priorities or how OFAC enforcement approaches particular matters. And my sense is that has remained constant. Even though the ebb and flow of the Treasury state dynamic continues, and we've talked about that a decent amount during the last podcast. I'm sure we'll talk about it more in this episode. There are, different at different points, the State Department may have more influence in certain decision making, or Treasury might. But when it comes to enforcement and BPI and some of those things where OFAC really is exercising its clear regulatory authorities, I think that the extent to which OFAC operates independent of the State Department remains fairly constant. And we'll I'm sure get more into the licensing process, but on that, there is a very well established practice, as Erik alluded to, of Treasury sending to state license applications that touch on particular foreign policy sensitivities or raise novel questions for foreign policy guidance. And, I'll just note my sense is, from having worked on these matters in both a legal and a policy capacity, Treasury tends to be quite deferential to the foreign policy guidance. And if state has a strong view one way or another on whether or not to issue a license, OFAC tends to listen to that. So, it's not rocket science, but for practitioners out there, I always advise that when applying for a specific license, I think that this is something that I would have said as well when I was at the State Department, bear in mind the foreign policy objective underlying the sanctions regime and how that license application might fit into the broader context and be consistent with the foreign policy objective, because that's how to move the needle and be viewed favorably by the Department of State.
Yeah, I just want to jump in and just add to what Erik and Josh said. I think from a practitioner's perspective, what that means is that OFAC enforcement is the most insulated from the current foreign policy of the whole sanctions process. And so, I think it's very wise to consider, the foreign policy when you're preparing a license application. But I think it would be foolish to conclude that you won't be an enforcement target for foreign policy reasons. That's a separate sort of law enforcement division of the government, and they really do take that sort of line of separation.
So even if the sanctions program is gone, like the Syria program, you don't take comfort in that if you're facing an enforcement action. We might see those enforcement actions for 9.5 more years.
And while you see that, I remember when Libya was wound down, or maybe Sudan. Yeah, Sudan was wound down. You would still see enforcement actions for several months after the official end of the program.
Yeah, and I may be speaking a little out of turn here, not having ever worked at OFAC, but my sense is that OFAC enforcement cares first and foremost about maintaining the integrity of the sanctions infrastructure and architecture, and that's kind of reflected in the Syria enforcement action from a couple of weeks ago now, where in the release they said, don't read the tea leaves. It really, the clear message from OFAC enforcement is that at the end of the day, they want to make sure that companies take the meaningful prohibitions, restrictions, consequences of sanctions seriously, regardless of the broader foreign policy objective underlying the sanctions. And that is distinct from the kind of front end implementation. And actually, I don't know, Erik, what your experience was like, but when I was in in particular, the Office of the Legal Advisor, I routinely found myself having to explain to people the difference between sanctions enforcement as a term of art and sanctions implementation. And, at the State Department, and this maybe goes to some of what we've talked about already about people who are very, seized of sanctions as a tool to use, but maybe lack some of the technical familiarity and detail, use the terms implementation and enforcement somewhat interchangeably. And I'd have to jump in and explain, well, sanctions enforcement has a very particular meaning. And for practitioners, for the private sector, and they hear enforcement, their ears they perk up, and that has a particular meaning that they're attuned to, and that is distinct from what we're talking about, which is making sure that the implementation of sanctions programs remains robust and that there's maintenance, and we're addressing circumvention and so forth.
Got it. Well, Melissa, you started this whole discussion off with your BPI question. Any follow-up on the interplay between OFAC and the state?
Well, I think one takeaway for banks, funds, other entities is that you're unlikely to get a cease and desist from state on a sanctions question, or a blocked property notice or something like that. The state may have had a role, but probably not, and it's going to be on OFAC letterhead.
So with that, which is sage advice, let's turn to delistings. And delistings have been a bit of a hot topic because there was a decision from the district court in D.C. earlier this week in a case called 3Nod versus Secretary of State involving the State Department process for delisting. But before I throw out a question on this, I just want to make very clear that both Josh and Erik are now in private practice. They worked in the State Department at one point. They do not speak for the State Department. They are not giving deposition testimony that could ever be used in a federal case. So do not try and bring a federal case out of anything that is said. We are speaking candidly, and if you try to do that, you will be mocked mercilessly, not only by us, but by anybody who looks at what you're trying to do. And with that intro, anything else you want to say in terms of caveats, Erik or Josh?
No, I think that's quite a strong foundation to start from.
All right, good. So any thoughts about the 3Nod case? For those listeners at home who have not read it, it was a decision from Chief Judge Boasberg that dealt with the question of what power your former offices had in connection with recommending delistings, and then in terms of recommending listings, recommending designations, and then making delistings as opposed to recommending delistings.
I mean, I think the first thing that jumped out to me from that decision was just the basic principle that with the authority to designate, to decide, as the court put it, comes the authority to reconsider. And so I think clearly recognized that where the State Department was the designating authority, the Secretary of State, then the Secretary of State is the appropriate authority to reconsider that the listing in the event that a delisting petition is received. And I think that seems like obviously the right approach, right? Where state has driven the original action, it makes sense that state is primarily responsible in coordination with OFAC for considering delisting requests.
Yeah, I agree wholeheartedly with that. And I suspect that OFAC wouldn't want to upset the apple cart with respect to that assignment, essentially, of State Department designations to State Department for delisting petitions, because everybody is extremely overburdened, and OFAC has now set up a whole reconsideration division, of course, but everyone has plenty of delisting petitions on their plate, and I think they're happy for state to shoulder the burden with respect to those designations that they made the initial determination with respect to. And the other thing just to note is there is a recognition, I think, in the 3Nod order that the State Department does track the approach as a general matter to considering delisting that OFAC has put in place, and that's reflected in the regs. And when I was in the legal advisor's office, we spent a lot of time working through kind of thinking about a State Department delisting process. And that was in part because, the State Department really in earnest began doing a lot of designations. I think probably during the first Trump administration. I mean, there had been plenty prior under counterterrorism authorities and so forth. 13224 gives the State Department the authority to make determinations with respect to imposing sanctions on the actors that are committing terrorism, and Treasury has the those that provide material support and act for on behalf of those that are designated based on State Department authorities. But it was really with the advent of state having a lot of Iran authorities under 13864 and so forth that I think there were more and more and more delisting petitions coming into the U.S. government that were in response to designations made based upon State Department determinations. And so it was around then when, people had to kind of start to grapple with, well, how does the State Department handle this? And I think there was a concerted effort to try and do it in a manner that's consistent with how Treasury does it, and look at things like change circumstance, change behavior, having gotten something wrong. And so I think that there is some recognition of that in the 3-Nod order, and that is a reflection on the fact that these are common principles that underlie these processes, regardless of the agency that is undertaking the assessment.
Yeah, and usually coming out of the same executive order based on the same standards. So it's just, it does make sense that you would have state reconsidering its own orders. I guess the question, in my mind is, do we think that state is going to change any of its practices coming out of 3-Nod? At least as I saw it, the holding is that the appointments clause requires the Secretary of State either to make the delisting decision or to delegate authority expressly to make the delisting decision. Do we think the Secretary of State would be inclined to delegate, or do we think that they'll just keep the power and what will come out of the EB is going to be a recommendation and not a decision?
Well, without getting too in the weeds and inside baseball and State Department process, my quick and dirty reaction when reading that and in response to, the question, you've really honed in on the heart of the matter. I think either of those things is not a huge lift procedurally. So, regardless of how state internally decides to approach this and figure out a process, I think it's a manageable issue. That's my sense.
Any follow-up, Erik?
No, I think that's right. I mean, the decision appears to leave a lot of leeway for the State Department to run the process, and so whether they'll adjust, we'll have to see what they do. But I agree with Josh. It seems like a manageable decision to follow up on.
Great. Well, with that, why don't we go a little bit more towards kind of the substance of delisting? So if I've got a delisting application in front of state, and I heard both of you say essentially the process is very similar with OFAC, that you didn't want to kind of reinvent the wheel at state with respect to the process. Anything different that I ought to be arguing if I'm making an argument to state for delisting than if I'm making an argument to OFAC for delisting?
I'd like to say no. I think, with respect to, both designations, and there were discussions around, there was an effort to stay in touch on delistings as well and to consult with each other. And so, I think there's an effort to keep the two agencies lashed up. Again, speaking from my own experience. And so, I think that, I think the agencies ideally we're going to be looking at it in fairly similar ways.
Yeah, I think that's right. One other kind of commonality is where there's litigation, regardless of whether it's a delisting petition put to state or to Treasury, DOJ will be involved, and it's kind of, my sense is the same lawyers and Fed programs who are working these sanctions issues regardless of the agency. So, I think that there really are commonalities in process, commonalities in the people, and as Erik noted, there's a healthy dose of discussion on delisting petitions between state and Treasury, that are often part of the broader policy discussion, but can often be also just specific to whatever the particular delisting petition is. And I just note, and going back to what I said previously about license applications that are sent to state for foreign policy guidance, of course, the State Department focuses on whether and how particular sanctions actions on the designation, licensing, or delisting side are consistent with the U.S. government's and the United States' broader foreign policy objectives. And so I think that that's always going to be front of mind at the State Department when working through some of these questions.
Great. Any follow-up from Melissa or Collmann on delistings?
Well, only that the case that came out this week didn't get to an intriguing question that I'm sure some future case will answer, and that is, can state really use OFAC's regulations? But that is an answer for another day, so we do not have to cover it.
All right. Well, I guess there were a few questions for another day. I mean, the other part was, that I found relatively intriguing is this whole backwards. Can sanctions be looking totally at backward conduct when the forward conduct has changed? And there is an argument that because sanctions are designed to change behavior, if the behavior is already changed, so that you can't change the behavior anymore, what is the point of imposing sanctions? But that was also left kind of to be decided later after the appointments clause issue.
Yeah, no, that's an interesting discussion that I think goes to the heart of the use of sanctions, and it also, I think, is relevant to how state and Treasury each and together build sanctions packages and the extent to which they look at information that's older than a certain number of years, and the focus on current status or recent conduct. And it does seem like it's kind of key to the question of whether and how sanctions are being used appropriately to advance the objective of inducing or coercing change as opposed to being punitive.
Yeah, I mean, I think those questions are out there with respect to sanctions, because my sense is, I mean, I talked to somebody in targeting, it's probably been 10 years ago now, who was telling me that we were talking about, old conduct, which was no longer relevant. Like the person had moved to another job, and the company was in a completely different place. And what he told me was that just doesn't come into play. We don't have any statute of limitations. We could go back 20 years, but we don't go back 20 years because we're looking mostly at current behavior. And I still think that, roughly lines up with what you see in the designations. But we are seeing, I think, some more designations where, the operating in a particular sector, by the time of the designation, this person is no longer in that sector, but the sanctions say operating in or operated in, and so at least the wording of the category is beyond the present tense, and it's being used, at least in my sense, it's totally anecdotal. It's being used more than it used to be for past behavior. All right. Well, that is delisting. What I heard you talk, Josh, a little bit about licensing, and I know, Erik, you talked about it a little as well. One of my questions with respect to licensing is, we do get these either emails back from OFAC, or you can see, I think, on the licensing tool that the matter has been referred over to state. It doesn't happen in every matter. My sense is that it gets referred over. If you're there, you're nearer to the end of the process than the beginning. But is that right? Is it usually not referred over until OFAC has kind of got a ballpark idea of what it wants to do, but wants to run it by state? Or is the licensing process, does state get involved early, and so the fact that it's been referred over to state means basically nothing? It just is, one step in the process.
That's interesting. I mean, and Collmann might have perspective here. And you're making me kind of kick myself, because I'm like, I should have asked more about that when I was actually in government, because I don't actually know. I didn't really probe a lot in like, what's the distinction between license applications that they would refer and those that they weren't. I mean, obviously, if there's a major sensitive foreign policy question, those are going to get referred. New programs where the policy is still getting sorted out, more likely to get referred. I mean, I know some of the parameters, but I don't have a great sense of everything either that they do before referring, or that sort of drives the distinction between referral and no referral. So curious if Josh or Collmann have more insight. I would say I do not think it is like, I wouldn't conclude that if it goes to state, you're near the end of the process. The State Department review can take some time. And then I think that's the main part of it. Like, the State Department review can take time. And the State Department has a queue of applications at any given time that is much shorter than what the OFAC licensing division is managing, but still is a meaningful kind of workload. And so if it's when you see that you get that little update, it's like with the interagency or whatever it says, it's a sign of progress, but I don't think it's a sign that you're sort of like near the end. And the State Department review and debate can be very substantive in terms of the merits of the application.
Yeah, I agree wholeheartedly with that, and focusing on the latter part of what Erik was just talking about. I mean, bear in mind, OFAC has a licensing team. State has 2 or 3 people who do a lot, the bulk of the licensing work. And oftentimes, I don't have a great sense of the universe of license applications that don't get sent to the State Department. We really have the most visibility into what did make its way to the State Department. And the license applications that come over are not cut and dry, because they do raise challenging foreign policy questions on which Treasury needs some sort of steer. And sometimes those can be resolved in a straightforward way, just an EB. Sometimes it means, involving the regional bureaus with relevant foreign policy equities. Sometimes they're difficult decisions that need to be kicked up to very high level review in the department, depending on the sensitivities in the program and so forth. And that can take quite a while. So I don't have a sense of how long license applications are at OFAC relative to how long they're at state, but they can be at state for quite a while, as Erik notes. I mean, I think that, for unblocking requests where it's really just a matter of a financial institution being, kind of overly risk averse or whatever else it might be, those are probably the kinds of things where there's no need to send it to state. But, if it's a question of operating somewhere, if it's a question of facilitating particular financial flows that may have a nexus to a malign actor or government, whatever it might be, that generates revenue. Those are things that raise pretty challenging foreign policy questions that folks are going to have to work through. And I think that there are few license applications that make their way to state where it's just a cut and dry yes or no without any real kind of meaningful consideration.
Looks like I'm going to have to answer.
I know
this
you
one.
weren't in licensing, but let's hear about it from the and just to be clear, so I was just sensing that you were nearer to the end of the process than the beginning when it went over to state. Not that the decision was imminent, but at least my sense from OFAC is that if OFAC looks at the license application and it's a hard no at OFAC, it's not sending it to state to say, can we deny this? That it's usually, if it's going to state, they might think that it's a hard no, but it's a harder, it's their sense is no, but it's a harder question, or their sense is yes, but we know this is a question that state ought to weigh into because we're not comfortable granting this without going through state, but that there are a bunch of license applications that don't even make it to state because they're just not something that OFAC would ever consider on its own.
What I always try to keep in mind when I was at OFAC is that OFAC is not a foreign policy agency. I think there's a temptation when you're in government anywhere adjacent to foreign policy to sort of think of yourself as the U.S. foreign policy branch, which is just not the case. The State Department has the lead in foreign policy. And the State Department, they have, I was really impressed by the knowledge of the FSOs at Post about the country that they were stationed in. I was really impressed by some of the functional bureaus within state. I remember Democracy, Human Rights, and Labor, DRL, which seemed to know a whole lot about sort of internet freedom in various countries. And so I think it's just, it's useful when you're in OFAC to remember that, the expertise on those issues is not within OFAC. OFAC focuses on correspondent banking, blocked accounts, the mechanics of its own regulations, and then the foreign policy sort of stays with state.
Perfect. All right. Well, and I think I love your idea, Collmann, about bringing somebody from licensing on at some point, because it sounds like between all of us, it would be nice to know exactly when it is that licensing decides to kick an application over to state, and when it doesn't. I take it from Coleman's comments that whenever there's a sense that they really want to understand the foreign policy better in order to make the licensing decision, that they're gonna bring state into the loop. But it'd still be good to know when that is and when it's not, because my understanding is that there's a backlog. The last I heard was like over 10,000 license applications at OFAC. With 2 or 3 people at state, I'm guessing that those 2 or 3 people are not being consulted on all 10,000 of those license applications, and so it'd be good to hear kind of when a case gets kicked over and when it doesn't. With that, why don't we talk a little bit more about any of the other things that, when you guys were at state, you were involved in terms of, decision-making process. I know we've talked a little bit before we got started about sanctions waivers, about other decisions that you would be brought into the loop of. But besides delisting and licensing, what else is there that you'd be kind of brought into the loop of after it's at OFAC? And I know that the enforcement, we've kind of carved that out, but any other things that you want to talk about in that area?
Well, so it just kind of ties back a little bit to some topics we touched on in the first part one, in terms of where the sort of momentum and impetus and policy push comes from in different programs. So we talked about, there's 3 main actors. There's the White House, there's Treasury, and there's state. And then in any given moment or program, other agencies can also obviously become important, but I think those are the 3 consistent actors. And in any given program, it can be any of those agencies that end up being the sort of primary, mover in terms of, sending the demand signal, like we think we should use sanctions, or we think it's time for another round of designations to achieve this goal or that goal. and and it doesn't always map onto where the targeting authority lies. So there are a number of programs where the targeting authority lies at Treasury, but there's a really heavy emphasis on the State Department providing input as to when and what kind of action would be appropriate in a given program. And then there's others where Treasury is much more forward-leaning in terms of setting the targeting priorities, and obviously informing and working with the State Department, kind of saying like, we know what we're doing here. We have a policy framework, and we're going to move out on it, and we'll consult. And then in any of those, at least during my time, the White House was heavily involved, at least in monitoring, and sometimes they were the mover. They would come from NSC saying, we need options, and so let's develop some options. And so I just wanted to point that out, that there's a lot of collaboration, but the demand signal can come from different places, and I wouldn't assume that it maps onto like where the targeting authority is. It actually ends up being sorted out a little bit more organically in terms of where the priorities are and who sees the urgency.
That's actually really helpful, because my sense is that sometimes the targeting authorities seem almost randomly assigned. I know that that's not quite the case, but it makes a lot more sense, at least to me, that there are certain issues that are foreign policy issues, whether they're assigned to Treasury or not. And I think to Collmann's earlier point, at that when you're sitting over at Treasury, you kind of are part of a foreign policy branch, but the real foreign policy branch is the State Department, and so it makes sense that you'd want the State Department both buy in and also weigh in in those times, even if the executive order hasn't anticipated that's how it's going to play out. Sorry, Josh, I know you had something to say.
No. I think that's precisely right. I mean, one thing I would just say to build on those insightful points is that I agree with Erik's description. I think that there is an incredible collaboration among State, Treasury, White House on much of this and on targeting priorities. There can be times where it's difficult for State because there is a particular foreign policy reason that the State Department has coalesced around to go after a particular target set, but they're Treasury authorities, and Treasury doesn't want to prioritize its resources in that way. It can be really tough, and there can be an interagency disagreement about whether to go after X, Y, or Z targets, whether to focus on particular types of targets that State really wants to focus on, but State just doesn't have the authorities. And we talked a little bit before about design of new sanctions programs, and there can sometimes be on the front end a lot of debate, to put it diplomatically, about where the authorities should reside. And I think that's been more of a focal point of the State Departments in these discussions over the course of the past several years, in part because there have been, take for instance, the Global Magnitsky Sanctions Program, which, it's human rights and it's corruption. And Collmann mentioned DRL. The State Department Bureau of Democracy, Human Rights, and Labor has the expertise in the U.S. government on human rights. And they and the Office of the Legal Advisor are the ones who are familiar with what constitutes a gross violation of human rights, a serious human rights abuse. And these are also concepts that show up in many other statutory areas and foreign assistance areas and whatever else that the State Department is empowered with. And so they want to use those authorities in certain ways, but it's Treasury that ultimately has the authorities with respect to GLOMAG. So that can, sometimes I think it works extremely well, but there can also be some challenging dynamics at times.
All right. Well, I think we've gotten through most of what we had at least planned out at the beginning to talk about. The one topic that we, have at least touched on a little when we talked about 3-Knot. I mean, is there any particular responsibility state has if any of these decisions are challenged in court? I mean, did you guys get involved in lawsuits? Like, what was your role when it came to lawsuits?
Well, I think that at the end of the day, if a State Department designation is challenged in litigation, it will be the State Department lawyers who are working most closely with Fed programs at DOJ on responding to the litigation. And again, OFAC lawyers and state lawyers work very closely because these are common issues, and they go oftentimes to the heart of the sanctions process and architecture in the U.S. government. And so OFAC, Office of the Chief Counsel, is going to have strong views on the arguments that are being made. But it's going to be incumbent on state, if it's a State Department designation or decision with respect to delisting or whatever else it might be, to kind of take that on, because it's the State Department that's being sued. I think, again, it's extremely collaborative, but the State Department does very actively engage in support of Fed programs, because they are the ones who are actually representing state in court.
All right. Any final thoughts, Erik?
No, none from me. Just appreciate the conversation. It's been a lot of fun.
Yeah, this has been a lot of fun, and at least for me, very informative. I mean, I really do think that there was a lot of mystery. There still may be a lot of mystery about kind of what the interaction was between OFAC and state, but Erik and Josh, I know you've helped me work through a lot of that mystery, and this was really helpful. Collmann and Melissa, any final thoughts?
No, I just want to thank both of our guests who are former DASs, which is a big deal in government, for coming on the podcast.
Yeah, thank you very much. And thanks to all the listeners. Stay sanctions free, everybody.
Produced by Heartcast Media.